Daly v. Choate et al., published by the 10th Circuit on November 3rd, 2025. It's about Equal Access to Justice Act fees for habeas. Habeas, of course, all the rage because immigration lawyers are being forced into it. We don't want to do it. We would love immigration judges to just release our clients and ICE to stop picking them up at OSEPs and really for no reason. In fact, I was provided a document today listing like a 20-step process. No progressive bastion, not a knock on the 10th Circuit. It's just, it is what it is. And saying, yeah, you can get EAJA fees for habeas, which that is a big deal because once the U.S. government has to start paying money, it makes them think twice. In order to get EAJA fees, the U.S. government, you have to succeed. If the case gets dismissed, if you reach an agreement with AUSA and they release your guy, like you can't get EAJA fees, which if EAJA fees are lurking in the background, it's another thing for the USA to go to their client, ICE, and be like, hey, I don't think that we can defend this. We might have to pay. Let's release your guy. So even if you don't get money, like it's a good thing. That's just civil litigation. The possibility of fees changes, or attorney's fees in general changes the calculus. And so it's an important part of civil litigation. If you win a habeas and then it's appealed, or quite frankly, you can get it in district court too. The US government had to not be substantially justified, or to say the other way, you can't get it if the US was substantially justified in their actions. You get a bond, no criminal record, immigration judge grants a bond, DHS doesn't appeal, DHS doesn't invoke the regulation, and they just refuse to let your guy go. They would invoke the rule, but there's an argument that even invoking the regulation is not substantially justified because it's an illegal regulation. In any event, if you took that crazy hypothetical that I just did and you won, and the AUSA didn't just release your guy, they wouldn't be substantially justified. Now, there's a lot lower things below that, and it's interesting. In this case, it was not an issue. It seems the government was conceding they weren't substantially justified, or they just didn't take it to the 10th Circuit. I don't quite know why. Because in this case, Miss Daly was convicted of second-degree murder in California, spent 15 years in prison, then went into removal proceedings, and she was there for many months, maybe over a year, it would appear. And she files a habeas petition demanding a bond hearing. Now, I'm not sure, she might not be even eligible for a bond hearing because of her conviction, but then there's the whole, does mandatory detention become unconstitutional after a certain amount of time? That issue hasn't been resolved. Certainly not in the 10th Circuit, I don't believe. But in any event, a court granted the habeas petition. And once she got a bond hearing before an immigration judge because of the habeas, the immigration judge said, actually, no danger at all, $1,500 bond, which is the lowest amount possible. And she was released. She spent 450 days in ICE custody. Now, I'm not going to lie, seems like they would have been substantially justified to fight that one, but it wasn't at issue before the 10th Circuit. So that's not the issue at all in this case. It's interesting. And so then they sued, though, for the 450 days in ICE custody, and the district court granted EAJA fees in the amount of $18,000. So not nothing. The issue before the 10th Circuit is whether you could get EAJA fees at all for habeas. That's actually a tricky issue. Apparently in the 4th and the 5th Circuit, you can't get EAJA fees for habeas, according to the 10th Circuit. And in the 10th Circuit, you can't get EAJA fees for habeas in criminal court. So like all the time, people imprisoned in state court, they'll bring a habeas action in federal court saying my conviction's illegal. Even if you win in that, apparently you can't get habeas fees. It says that that's 10th Circuit law. And so the question is, you can get it for civil action. Is a habeas requesting the release of a immigrant detainee a civil action, or is it more akin to the habeas criminal, where the criminal person is requesting their release? 10th Circuit says it's more like civil. Supreme Court has said that. Old English law has said that. We're talking civil immigration detention, even though it's like the same as criminal detention. So just the fact that you can get EAJA fees at all is a big deal. Might be the first case of its kind decision. I'm not sure. Great quotes. Quote, habeas petitions play an important role in challenging and deterring unlawful detention, end quote. So big deal out of the 10th Circuit.